All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
L'audience est ouverte.
Presiding Judge Mindua. Courtroom officer, could you please call the case? Thank you, Mr. President. Situation in the Republic of Mali. The prosecutor versus Hassan Abdul Aziz Muhammad Mahmoud, ICC 01120118. We are in open session, Your Honor.
Il me semble que nous avons quelques problèmes.
Judge Mindua, it would seem that we have a few problems concerning the interpretation as far as the accused is concerned.
Merci.
Judge Mindua, thank you.
Bonjour.
Good morning.
Je souhaite la bienvenue
I would like to welcome the parties and participants,
au personnel des chambres
as well as the staff members from chambers and the registry who are present in the courtroom,
ainsi qu'à toutes
and all those who are following these proceedings remotely.
Je constate que M.
I note that Mr. Hassan is present in the courtroom.
Bonjour, Monsieur.
Good morning, Mr. Hassan.
صباح الخير.
Good morning, Your Honor.
Asseyez-vous. Merci. Asseyez-vous.
Judge Mindua, thank you. Please be seated. The Chamber would like to thank the Registry for having endeavoured to make this hearing possible,
En particulier,
especially during these times of limited human contact as a result of the current pandemic.
je suis aussi particulièrement content
I'm also particularly
de trouver tout le monde en bonne santé.
thankful to see that everyone is in good health after this extended period of confinement and closure of the permanent premises of the court.
Mais le virus est toujours
But the virus is still in our midst,
prenez soin.
so please take care of yourselves.
Avant de commencer,
Before we commence the hearing,
nous devons nous
we must ensure that the accused understands
qui sont mises à la disposition
the languages of this hearing,
le français,
that is to say, French, English, but also Arabic.
Monsieur Alassane,
Mr. Hassan,
c'est à vous que la Chambre.
the Chamber is addressing you now.
Monsieur Alassane,
Mr. Hassan,
nous indique
can you please indicate to us whether you have indeed received interpretation of what I have just said in a language that you understand? Mr. Alassane, please.
نعم.
Très bien.
Judge Mindua, very well. I do understand Arabic words, some Arabic words, but I don't hear the interpretation from Arabic into French in my headset, says Judge Mindua.
Merci beaucoup.
Thank you very much.
À l'accusé, Monsieur Hassan,
To the accused, Mr. Alassane, to the victims who are following these proceedings from afar, to the people who are taking part in the hearing here in the courtroom or remotely,
à présent,
may I now remind you
position de la Chambre
of the composition of this chamber,
pour le plus grand nombre,
or for most of you, actually introduce the members of Trial Chamber 10 who will be examining this case.
cette Chambre
This chamber,
que j'ai l'honneur de
over which I have the honour of presiding, is composed of, to my right, Judge Tomoko Akane, and to my left, Judge Kimberly Prost,
et de moi-même,
and myself,
Antoine
Antoine Kassia Mbe Mndua, presiding judge of this trial chamber.
Je souhaiterais
I would now like to call upon the parties and participants to introduce themselves.
puis-je demander
May I
à Madame
ask
la procureure
Madam Prosecutor
de se présenter,
to introduce herself and the members of her team, please.
Madame la procureure.
Madam Prosecutor.
Mr. President, the Office of the Prosecutor is represented today by Mr. Gilles Dutertre, Senior Trial Lawyer, Ms. Diane Luping, Trial Lawyer, Ms. Sarah Kukio, Assistant Trial Lawyer, Associate Trial Lawyer, and Musa Alafi, Assistant Trial Lawyer. Thank you, Mr. President. And myself, of course, Fatou Bensouda, Prosecutor.
Merci beaucoup, Madame la procureure.
Judge Mindua, thank you very much, Madam Prosecutor. I will now ask the representatives of the defence team from Mr. Al-Hassan to introduce themselves. Ms. Taylor?
Good morning, Mr. President. Good morning, Your Honours. Good morning, colleagues. My name is Melinda Taylor, and I'm appearing on behalf of Mr. Alassane today with Ms. Nicoletta Montefusco, Mr. Mohamed Youssef, Ms. Saha Marinia Duse, and Ms. Dolly Chala. Thank you.
Merci beaucoup, Maître.
Judge Mindua, thank you very much, Ms. Taylor. Now I will turn to the legal representatives of victims.
Puis-je vous demander de vous présenter?
Could I please ask you to introduce yourselves and the members of your team?
Merci, Monsieur le Juge Président.
Mr. Luwenjika, thank you very much, Presiding Judge, Your Honours. The team of the legal representatives of victims comprises Mr. Kosongo Mayombo, Mr. Doumbia Seydou, who has not been able to come because of the situation, the health situation that we are only too familiar with, that is to say COVID-19, Madame Lupage and Madame Biyeke, and myself, Fidel Nsita, Counsel. Thank you.
Merci beaucoup, Maître.
Judge Mindua, thank you very much, Counsel Nsita.
Je ne sais pas s'il y a un représentant.
I don't know whether there's anybody representing the Office of the Registrar in our midst today, and I'm told
Très bien.
that no. Very well.
À présent, je vais tout d'abord
I would like, first of all, to make a few general observations
concernant les principes.
concerning the main procedural steps of this case.
Ensuite, les charges seront.
Then the charges will be read out to the accused,
Ce dernier
and he will have the
aura la
possibility
de plaider
to
coupable
plead guilty
ou non coupable.
or not guilty.
Nous procéderons
We shall then move on to the opening statements from
Madame la procureure
the Office of the Prosecutor
et probablement ses substituts.
and
Les représentants légaux des
the
victimes
legal representatives of victims and defense counsel
quant à eux,
have chosen for their part to
présenter leur déclaration liminaire à une date
present their opening statements at a later date,
au début de la présentation.
before the presentation of their evidence.
Et nous n'entendrons
So,
pas
we shall therefore not be hearing their opening statements today.
Je rappelle que M. Al-Hassan
I recall that Mr. Al-Hassan was transferred to The Hague on the 31st of March 2018,
suite à la délivrance
subsequent to the issuance of a warrant of arrest against him by Pre-Trial Chamber 1.
au terme de la procédure
Subsequent to the procedural work undertaken by the Pre-Trial Chamber,
de confirmation des
a
charges
confirmation of charges hearing was held in July 2019,
et
and
la décision
the document
confirmant les charges
containing the
a
charges
été rendue
was issued
le 30.
on the 30th of September 2019.
Évidemment, je marque de pause.
Of course, I'm pausing for the interpreters to be able to keep up.
La chambre préliminaire
The pre-trial chamber
ensuite rendu
then issued a decision amending the charges
le 23
on the 23rd of April
2020.
2020.
La présente chambre
This chamber
a été constituée,
was constituted
saisie
and
cette affaire
seized of the
au mois
case
de novembre
in
2019.
November 2019,
Depuis lors,
after which
une phase
there
de
ensued
résultat du procès
a trial preparation phase
à un rythme soutenu
in order to rapidly prepare
destiné à préparer
for the
le début
substantive
des
part
débats qui
of the
s'ouvrent
case,
sur le
which
fond aujourd'hui.
commences today.
Nous en venons à la lecture des charges et au plaidoyer.
We come now to the reading of the charges and entering of pleas.
Selon l'article 64
Pursuant to Article 64.8 of the statute,
à l'ouverture
and I quote,
du procès,
at the commencement of the trial,
la chambre
the
de
trial
première
chamber
instance
shall have read
fait donner lecture aux
to the accused
des charges
the charges
préalablement
previously
confirmées par la
confirmed
chambre
by the pre-trial chamber.
La chambre de
The
première
trial
instance
chamber shall
s'assure que l'accusé
satisfy itself
comprend
that the
la nature
accused
des charges.
understands the nature of the charges.
Elle donne lecture,
It
elle donne à l'accusé
shall
possibilité
afford him or her the opportunity to make an admission of
selon ce
guilt
qui est prévu à l'article
in
65
accordance with Article 65 or to plead not guilty. End of quote.
conformément à l'article 64.
Pursuant to Article 64.8 of the statute,
Il va donc être donné lecture
the charges will therefore be read out to the accused
des charges telles qu'elles sont énumérées
as set out in the self-contained set of charges,
les charges.
which was drafted
The self-contained set of charges. Document qui a été rédigé
which was drafted in preparation for this hearing
sur la base de la décision
on the basis of the decision containing the charges and the decision
rendue par la
modifying the
préliminaire
charges issued by the pre-trial chamber on, respectively, the 30th of September 2019 and the 23rd of April 2020.
certains éléments
Some
relatifs
elements of the
aux
charges
charges restant à ce stade
remain
confidentiels
confidential at this point
pour assurer la protection des
in order
victimes
to protect the
concernées.
victims concerned,
Ces charges seront lues
and they will be read out in closed session.
Il lui sera demandé
The accused will be asked if he understands the nature of each charge.
Il sera également demandé
Mr. Al-Hassan will also be asked
s'il entend
if he intends to enter a plea
plaidoyer
of
de
guilty
culpabilité
or not guilty.
ou de non-culpabilité, étant rappelé
Though it should be recalled
pas une obligation
that this is
pour
not
l'accusé
an obligation
en vertu
for the accused under Article 64(8) of the statute.
au préalable, la Chambre estime
Firstly,
qu'il est nécessaire
the Chamber is of the opinion that it is necessary to read a brief summary of the charges brought against the accused,
dans le but
with a view to informing the public
de la nature
of the nature of the hearings on the merits that commence today.
Je note que ce
I note that this summary
n'est pas de nature
is not a
à
substitute
substituer
for the charges
aux charges telles que confirmées
as confirmed by the pre-trial chamber.
parce qu'il s'agit simplement
It is simply a presentation of the case
public
to the public
qui nous écoute aujourd'hui.
listening to us today.
Présentation
This presentation
possible
can also be found
trouvée
in the documents
document mis à
made available to the public and the media
l'unité des affaires
by the Public Affairs Unit of the Court.
Je vais donc procéder à un tout petit
So, I shall provide you with a very brief summary.
L'affaire portée devant cette
The case
chambre concerne
brought before this chamber concerns the following facts.
entre le 1er avril
Between the 1st of April 2012
et le 28
and the 28th of January 2013,
les groupes armés
the armed groups
en Sardine,
Ansardine,
ACMI,
ACME,
constituant
constituting an organization,
auraient mené
allegedly carried out a widespread and systematic attack
contre la
on the
population
civilian population of Timbuktu
et de la région.
and of the region which bears the same name.
Pendant cette période,
During that period,
en Sardine,
Ansardine,
ACMI
Akim in English,
aurait
allegedly imposed its ideology on the population,
et
and to this end,
les membres
the members of
d'Ansardine
Ansardine Akim
auraient commis
are alleged to have committed multiple crimes under Article 7.1 of the statute,
en application
pursuant to or
la
in furtherance of
de la politique
the policy of the armed groups to
ayant pour but
conduct
telle
such an attack.
les actes reprochés auraient
The
été
acts
commis
charged are alleged to have been committed as part of this attack
Il s'agit des crimes
and
de torture,
are as follows:
chef,
torture, count 1,
autres actes
other inhumane acts, count 2,
autres actes
other
inhumains
inhumane acts
prenant la forme
in the form
de
of
mariage forcé,
forced marriages,
chef,
count 8,
esclavage sexuel,
sexual slavery,
chef,
count
9,
9,
viol,
rape,
chef,
count 11,
et Sécution.
and persecution,
Chef 13.
count 13,
En tant que crime,
as crimes against humanity.
d'autres crimes visés aux articles 8
The crimes under
paragraphe
Article
2
8 to C
et 8 paragraphe
and
2
8 to E
du
of the
statut
statute
est reproché
with which
à M.
Mr. Al-Hassan is charged
aurait été commis
were allegedly committed in the
d'un
context
conflit armé
of
ne
a
présentant
non-international
un
armed
caractère
conflict
international se déroulant au Mali
taking place in Mali
période
at the material time
et y
and
seraient
are
associés
linked to the armed conflict.
les actes reprochés
The acts charged are as follows:
torture
torture,
chef
count 3,
traitement cruel
cruel treatment,
chef 4
count 4,
atteinte à la
outrages
dignité de la
upon
personne,
personal dignity,
chef
count 5,
le crime de
the
condamnation
crime of
prononcée
passing sentences without previous judgment
rendue par
by a
tribunal
regularly constituted
régulièrement
court,
constitué, assortie
affording
de garanties
all
judiciaires
judicial guarantees
généralement reconnues
generally acknowledged as
comme
indispensable,
indispensables. Chef
count
6.
6.
Le crime d'attaque
The crime of directing
contre les
attacks
biens protégés,
against protected objects,
chef 7.
count 7.
Le crime
The crime of
d'esclavage
sexual slavery,
chef
count 10.
et viol,
And of rape,
chef 12.
count 12,
En tant que
as
crime
war
de
crimes.
guerre. Monsieur Alassane
Mr. Al-Hassan
aurait exercé
is alleged
quotidiennement
to have
des
exercised
fonctions et des pouvoirs
powers and functions on a daily basis
de la police islamique
within the Islamic police
et au sein
and
de
within the organization,
et il aurait
and is alleged to have contributed
activités
to the activities of the organization
à Tombouctou
within Timbuktu
au moins
from
dès
the 7th of May at the latest,
2012
7th of May 2012 that is,
jusqu'au 28 janvier
until the 28th of January 2013.
Sur cette base, Monsieur Alassane
Mr. Al-Hassan is alleged
pénalement
to be criminally responsible for the crimes set out
au chef
under the aforementioned counts 1 to 13
de charge
as
cité
confirmed
et tel que
by the pre-trial chamber.
ce résumé étant lu,
Now that we have read out the summary,
passer à huis clos
we shall now move into closed session
pour donner lecture
to read out the entirety of the charges
confirmée
confirmed by the pre-trial chamber.
préliminaire. Pour l'information du public,
For the attention of the public,
je note que
we should
nous
be
devrions être
returning
retour à
into
session publique
open session
dans environ
in
45 minutes.
approximately 45 minutes.
Madame la greffière
Madam
présidente,
Courtroom Officer,
veuillez passer à
may we
huis clos.
go into closed session, please?
Nous sommes en audience publique, Monsieur le Président.
The Courtroom Officer, we are in open session, Your Honour. Judge Bandua, very well, thank you very much, courtroom officer. So, I will now turn to Mr. Hassan to ask him if he understands the nature of each charge against him and to afford him the opportunity to make an admission of guilt or plead not guilty pursuant to Article 64(8) of the statute.
Je constate que Maître Taylor.
Judge Bandua, I can see that Ms. Taylor is on her feet. Ms. Taylor, please.
Thank you very much, Mr. President. With your permission, I would ask that the Chamber allow Ms. Montefusco to address the bench on the specific issue of Mr. Al-Hassan addressing these questions. Thank you.
Allez-y, Madame.
Judge Bandua, please, Counsel Montefusco, you have the floor.
Okay. Is the chamber able to hear me? Yes. Okay. Thank you, Your Honors. This morning, the defense would like to verbally raise the motion asserting its doubt of the accused's fitness to stand trial at this time. And it moves the chamber to order a qualified examination to assist it in making this determination and also to assess whether Mr. Al-Hassan has the capacity to meaningfully exercise his fair trial rights that are enumerated in Article 67 of the statute. And they are further detailed, which are in the filings, so I will avoid going into the judgments themselves of Gbagbo, Ongwen, both of which refer to the Strugard fitness decision in the ICTY. In the Chamber's taking into account of all the relevant circumstances in this particular case to determine whether the putting in place of certain practical arrangements could have mitigated the negative impact against a fair and expeditious trial, the latter appears to be the predominant concern of the Chamber. It is the defense's position that prioritizing expeditiousness to the fundamental precondition to trial of fitness is paramount to the rendering of all of the accused's fair trial rights so that they are not merely illusory and therefore engage in absolute prejudice to the defendant. With respect to the issue of timeliness, the fitness to stand trial doesn't expire. It is an issue that can be raised at any time throughout the proceedings, beginning with the initial appearance, clear through the rendering of a verdict. It is even an issue that can be raised retrospectively. And therefore, it is the defense's position that, contrary to the Chamber's position, that the order that motions having repercussions on the conduct of the trial must be submitted in a timely manner also applies to a defense motion raising a doubt as to the fitness of the defendant to stand trial does not apply. The prescription to the raising of a doubt as being untimely or even as causing undue delay amounts to an arbitrary self-ascription of discretion, which applying to a precondition to trial, namely the fitness to stand trial, to meaningfully participate in the exercise of all of his fair trial rights, cannot be superseded by expeditiousness. The defense has repeatedly and consistently throughout the procedural history of this case raised this issue in its termination request, again in the status conference on the 30th of June, again in the adjournment series, the filings, again in the fitness filings, and again this morning at 10 a.m. During the status conference on the 30th, the single judge acknowledged that the defense, once it had the chance to meet Mr. Al-Hassan, might have other matters to bring before the Chamber and that the Chamber would receive them, as it was sympathetic to the situation the defense is facing in terms of discussing matters with its client. In that regard, the defense had to seek a court order to effect its request to visit its client in person given the challenges that COVID has posed against all parties and also the court, the defense wasn't able to see Mr. Al-Hassan. When the defense met him for the first time in 4 months, the defense was alarmed with the current status of their client. Engaged in a discussion with him, and based on the results of the defense's in-person meeting on that day, the defense sought to confirm or disconfirm, or even simply to understand whether or not the alarm that it sensed was valid, and asked Dr. Porterfield to have an emergency phone conference with him, who is an expert of trust to Mr. Al-Hassan. She issued a letter on July 8th of 2020, which the defense has provided to the chamber, acknowledging that he was experiencing dissociative features that result from severe maltreatment, causing serious impairment and distress, and very importantly, the avoidance of memories. She then went on to state, he is experiencing dissociation, which is a neuropsychiatric symptom in which there is a rupture in sensory experiences and perceptions of oneself and of the environment. Fitness to stand trial requires that the accused is not only able to understand the charges against him, but that the accused is able to conceptualize the outcome or the consequences of the trial that he is facing. That requires that he is able to completely assist defense counsel in preparing his defense. And that requires, looking at the fourth capacity in the Struger decision, that he has the ability to understand the details of the evidence. How can somebody who is experiencing such post-traumatic stress that they are dissociating in a way that they avoid memories, properly assist counsel in analyzing the evidence that to date it still has not had the opportunity to even investigate, in order to prepare an adequate defense? So with timeliness not being an issue by law, the defense is moving this court verbally, and has done so in writing as of 10 a.m. this morning, to order assessment of fitness to stand trial of Mr. Al-Hassan, because at this time, the defense affirmatively raises the doubt that he is actually fit to proceed.
Merci beaucoup, Maître. Vous avez...
Thank you very much, Counsel. You have noted that the Chamber followed very attentively what you just had to say. Now, in reality, if I understand you correctly, you are saying that your client is not fit to stand trial for the time being, but the Chamber has been regularly seized of the matter as to whether he is physically able to stand trial or not. You cited the name of the doctor, but according to the doctor's report that I have in my possession, he has said that a clinician would have to be in a position to be able to examine the accused. We have not yet been seized of the matter. Your team filed some submissions, and the Chamber has deliberated upon these. I would like to remind you of a number of said decisions just after the pleas entered by the accused, I will do so. And as you are raising this issue now, I see that we have 10 minutes before the break. The chamber shall withdraw with a view to answering your question upon its return, and also read out or rather recall the decisions that have already been taken on the matter with regard to which you have filed further submissions. The chamber shall now withdraw, but before we do so, I would like to know whether the prosecutor has anything to say in this regard. Madam Prosecutor. Mr. Dutertre. Mr. Dutertre, good morning, Your Honour. Good morning, Your Honours. I shall try and be very brief.
This request is obviously late. The opening was set for today at 10 o'clock. At 9:57, we got everyone a courtesy copy of a defense request on Mr. Al-Hassan's fitness. This is literally last minute, 3 minutes before the opening of the trial. And this is way after the 1st of June deadline for motion requiring resolution before the commencement of trial, a deadline that was postponed to the 16th of June based on a request by the defense. Expeditiousness, Your Honors, as the ongoing appeals judgment number 1562 as underscored in paragraph 2, I quote, forms part of a trial. Procedural rules that require parties to raise certain issues at a given point in time are not necessarily incompatible with the rights of the accused. End of quote. More generally, the appeals chamber has emphasized that parties must act within a reasonable time, especially regarding objections that may impact on the expeditious conduct of the proceeding. And I'm referring to the Katanga appeal judgment number 2259, paragraph 54. In the present case, there was ample of time for defense to file such a request before and to organize an ad hoc phone call with Mr. Porterfield, as they did on the 8th of July. What they did on the 8th of July, they could have done before. There are, that being said, clear indicia that Al-Hassan has an overall understanding of a proceeding and also has the ability to provide specific instructions to his counsel. And there is insufficient evidence of lack of fitness. Defense is relying on his own consultant report, which remains to be tested. And in fact, there are indicia today of the contrary that he is fit to stand trial. In this context, the prosecution considers that the defense request for reconsideration of a decision on the defense adjournment request is moot. This late request sent this morning can be dealt with before the presentation of the actual evidence, starting 25th of August. We can proceed today, and the accused will be afforded an opportunity indeed to make an admission of guilt or to plead not guilty, as you had suggested, bearing in mind that it is not an obligation. So for this reason, the prosecution requests that we shall proceed today and continue the opening. Thank you, Your Honors.
Merci beaucoup, Monsieur le procureur.
Presiding Judge Mandua. Thank you very much, Mr. Duterte. Ms. Taylor.
Thank you very much, Mr. President. Given that the defence should generally have the right of the last word, I wish to address one discrete point, one very important factual point. Possibility is the limits of the law. And until this very day, we have not been able to have an expert go into the detention unit and see Mr. Al-Hassan. And I think any expert on medical issues would laugh you out of the courtroom if you were to say that you could do a proper fitness assessment with someone you do not know on the telephone. So for the last 4 months, we have regularly, repeatedly insisted we need to go into the detention unit. We have put that in almost every filing. And in so doing, we have linked it to the need to conduct proper assessments of his fitness. We have placed all the information that we had on his fitness that was prepared before COVID in our 16th of June filing, and we asked for an evidentiary hearing so that the doctors could be here and you could question them about dissociative disorder. But what we cannot do is waive a fundamental right, even if it's not an obligation, it is a right to enter an informed plea, just because COVID has prevented Mr. Al-Hassan from seeing a medical expert. And we have been prevented from actually facilitating that and have it happen. So it's all very well and good to talk about COVID and how it's impacted upon persons, but thus far, the only counterbalancing remedies that have been given to one side of the courtroom and not the other. And as a result, it's created a significant inequality of arms. It's impeded our key defense preparation, and yet when we move the chamber for a remedy, we're being told we're not timely for reasons beyond our control. And even though issues of fitness are not static, again, we've been repeatedly saying issues of fitness will depend on his conditions. They'll be impacted by COVID. There's the likelihood it would worsen. These are issues that raise the doubt that impelled us to file today's request. We cannot do earlier what's not possible. And Mr. Al-Hassan, as a defendant in this trial, should not have these fundamental rights put in peril because of issues beyond our control and because of bureaucratic formalities that could not be fulfilled in an effective rather than illusory manner. Thank you.
Merci beaucoup, Maître Taylor.
Judge Mandua, thank you very much, Ms. Taylor.
La Chambre va se retirer.
The chamber shall now withdraw. It's virtually time to take the break anyway. The break will be of 45 minutes of duration. So in 45 minutes' time, we shall reconvene and we shall hand down a decision with regard to what you have just raised.
L'audience est suspendue.
Court is adjourned.
All rise. Veuillez vous lever.